Enzorecto, kalaban ang katiwalian at kasinungalingan, kakampi sa katotohanan at kabutihan.
At wala pa ring desisyon na nangyayari. Bakit parang double standard yon? Can you weigh in on that, sir?
Palagay ko po, depende sa nature of the offense charged. In the case of Senator Jinggoy, it's not bailable kasi, so even if he's still presumed innocent under the law, he has to be detained because of the nature of the offense charge. Palagay ko yung binabanggit niya na facing also criminal charges, the witnesses, they are not similar non-bailable offenses.
But specifically, on the request po of Senator Rodante Marcoleta na kung pwede siyang makapag-participate and then bumoto later on this impeachment trial, is that something that is within the realm of what is possible?
It is to me very remotely possible because the charge there is non-bailable. And it's up to the court, Sandigan Bayan, to allow, and so far they have stated that they do not allow such arrangements.
Attorney, ako naman po may isang question po ako. Siguro on the conduct ng ating mga senator judges on what we've been seeing so far, no. Alam ko po na they can ask questions to the witnesses, clarificatory questions, but how come po parang sometimes they're asking questions either to the prosecution or to the defense, and when they do, minsan nagiging somehow a little disrespectful. Is that even part of the impeachment process, sir? Or is it supposed to be clarificatory questions only directed to the witness?
The presiding officer has the discretion to handle questions whether they come from the prosecution or the defense or from the senator judges themselves. Sometimes there's need to rephrase the question for the clarity so that the witness can answer it correctly. So sometimes the presiding officer may do that, may rephrase. I noticed this Senator Jesus Cordero has done that in the past to rephrase the questions to make it more intelligible.
Okay. Justice Ascuna, yung pong mga testimonya ni Director Matibag at laging paulit-ulit na sinasabi niya na based on the parang tests that the FBI actually adheres to, no, when proving the innocence or the guilt of a respondent. Sabi niya, in the case of VP Sara, tiningnan nila yung pattern of violence, merong gravity and seriousness of the threat, among others, the capacity to execute threat. Okay, pumasa daw doon, Justice. Ang issue ngayon dito is wala pa rin silang maituro kung sino yung tao na kinontrata ng pangalawang pangulo upang isagawa yung pagpatay na pinag-uusapan. Parang it's a gaping hole, no? Dito po sa parte ng prosecution o ni Director Matibag. How will that affect po yung posisyon ng prosecution in terms of proving that indeed the Vice President is guilty of what she's being charged with?
Sa tingin ko po, ang element ng contracting the assassin is not necessary to be proved. Kasi grave threats lang ito, hindi naman attempted murder ang charge. So as long as the threat is proven, whether or not it was carried out is not necessary. As long as the criminal intent to threaten is proven.
I see. Okay. Let's talk about the Las Cañas testimony. Matagal po ang inubos na oras dito ng prosecution at ng defense dahil ang sinasabi po ng defense, unang-una, hindi naman notarized yun. Hindi naman sworn to yung affidavit na yun na pinulot lang mula do sa mga sinubmit o sinumite sa ICC. Kung ganun po, tama po ba yung binabanggit nila na wala pong probative value yon? Ano yung papel nung keynote nila ng mga Las Cañas testimony na yon?
Palagay ko very incidental. Incidental na yon dahil hindi kailangan yan to prove the intent of Vice President Sara Duterte in making the threat. Yun po ang essential thing as far as this article is concerned. The side issues of this Las Cañas and the contracting the assassin, they are not necessary to prove the criminal intent behind the threat.
Taking into the line of questioning din po, and yung sinabi po ni Senator Robin Hood Padilla regarding this din po, no, ni-retract po kasi ni Las Cañas ang statement niya eventually, no, at Senator Robin was pointing out, kung ni-retract, edi pwedeng masabi natin na yung una niyang sinabi ay possibly hindi totoo. Will the senator judges still take it at that face values, justice, or dapat po bang talagang sweep it to the side and they don't really have to think about it because sabi nga ni Senator Chis, hindi naman natin ito iti-treat as evidence.
Yun nga, mga palagay ko, hindi essential itong mga matters na ito to the issue of whether or not the threat was made with criminal intent. These are side issues which are not necessary to prove that point.
Okay. Justice, meron din silang ipinakitang video na binanggit ni Baste Duterte na sabi niya, isang ulo lang naman ang kailangan natin, ang ulo ni Bongbong Marcos o ni BBM. Ang tanong po ng marami, ano ang kinalaman nun doon sa kinakaharap na kaso ni VP Sara? I mean, iba naman si Baste, iba naman si VP Sara, di po ba? Bakit po ikino-connect yung dalawa na yon?
Palagay ko yung intention is to show that the criminal intent in question is something that has also been shown by other members of the family. But I think that is irrelevant. Ang question dito yung respondent, is the respondent guilty of threat, not only making the threat but making it with criminal intent. Yan ang issue po.
Yun.
Pwede ko po bang susugan din po yung point ni partner doon at Justice, no? Tinabi side by side yung kay Mayor Baste at kay VP Sara. Senator Ping asked of this bakit si Baste ay hindi kinasuhan or inimbestigahan the same way that VP Sara is being investigated now? On the bounds of law, ano po ba yung paano po ba natin ito dapat titignan, Justice?
That is up to the government to answer, but again, I say that let's stick to the issue here. The issue is whether or not the specific threat made by the Vice President is a criminal in nature.
Yun po bang actuations at mga statements ng kanyang kapatid, ng kanyang ama, ay makatutulong sa pag-build ng case na sinasabi ng prosecution ay may tendency to a violent nature ang Vice Presidente?
Palagay ko, that is not a necessary element, whether or not the other members of the family are also given to making threats, no? The issue is whether or not this specific threat is proven by the prosecution to have been made with criminal intent. And this can be proven, as I said before, by the, among others, by the behavior of the persons threatened or the persons mandated to protect them, whether or not they took this threat seriously.
Opo.
And the NBI has indicated that they took it seriously because of the capacity of the person threatening to carry it out. They don't have to prove that she carried it out. It's just the capacity. What is needed is to prove that the persons threatened or the persons guarding them treated it seriously, in which case that is considered one of the indicia of the nature of the intent behind the threat.
Finally, on this topic, Justice, before we move to what can happen next week, sa palagay po ba ninyo, the prosecution and the defense has done their part on, first, on the prosecution side, proving their point on the grave threat, at yung defense po ba has dented yung argument ng mga prosecution?
I didn't get the question again, please.
Opo. Kung i-analyze niyo po, bibigyan niyo po ng grade yung prosecution tsaka yung defense, sa tingin niyo po ba nagawa nila yung trabaho nila pagdating sa Article 4 on proving that there is a grave threat, and on the defense side, making a dent sa argument ng prosecution na wala kayong basihan sa grave threat argument ninyo?
Oh, okay, I pointed out that when the prosecution was able to prove that not only was the threat made because of the video, which is not controversial, but the intent behind it is shown to be criminal because of the way the persons threatened or those mandated to protect them, the way they receive the threat, they receive it seriously. So that is already an indication of criminal intent. So I said the burden of the evidence shifted, not the burden of proof. The burden of proof is always with the prosecution, but the burden of the evidence shifts during the trial. So the burden of the evidence here shifted to the defense, for the defense to show that in fact, what was stated was not criminal intent. It was just out of anger, or she was not serious, or whatever justification. That is now the burden of the defense. Now, whether or not the defense has been able to carry that burden is for the central judges now to weigh. Of course, they also have their time to present their witnesses. So this matter is not necessarily closed yet.
Justice, one final thought, no, and this is a recurring question, lagi pong napag-uusapan ito na in an impeachment proceeding po, tama po ba yung binabanggit ng marami na hindi kagaya sa court of law where the threshold to prove guilt is the threshold is much lower than in a regular case in a regular court, which demands guilt beyond the shadow of a doubt. Can you explain that to us, please, sir?
Yes, ito pong impeachment proceedings, hindi po kagaya ng criminal case where the guilt of the accused has to be proved beyond reasonable doubt. But what is the threshold of evidence needed to sustain a verdict of guilty in an impeachment case? It is not settled exactly what kind of threshold, but I would say it is clear and convincing evidence, clear and convincing for the minds of the central judges to, in their belief, to support an impartial conclusion that the article in question has been proved to their satisfaction. Yun po ang remember again that the central judges are not professional judges. They are actually elected representatives or politicians in nature. So you have a legal process, but a political judge. So this is a blending of law and politics.
And to say that Senator Judge must be politically neutral, is that is that something that we can hope for, or press release lang yun?
That is a difficult thing to say, but what is required is not political neutrality, but an impartial mind.
Ayun.
They will remain politically what they are.
Opo.
But they will try to judge according to the evidence with as much impartiality as possible.
Bunyog, bunyog, halikan na kasama ka. Bunyog, kapag buklod ay may pag-asa. Luzon, Visayas, Mindanao, isa ang pananaw. Sa bagong Pilipinas ang bunyog isisigaw. Bunyog,